Good afternoon, everyone. Welcome to our Medical Board of California Panel B meeting of January 25th, 2017. And we will call this meeting to order at 3:42, and we take the roll. Thank you.
Ms. Lawson?
Here.
Dr. Gonadab?
Here.
Dr. Kraus?
Present.
Dr. Levine?
Here.
Ms. Pines?
Here.
Ms. Sutton-Wills? Dr. Bollock?
Here.
We have a quorum.
Thank you. And today we welcome Judge Lynn Woolard, who will be presiding.
Good afternoon. This is the date, time, and place set for oral argument regarding the proposed decision issued in the matter of the statement of issues against Kenneth R. Weissman, MD, case number 800-2015-019218, Office of Administrative Hearings, case number 2016-040983. My name is Marilyn Woolard. I'm an administrative law judge with the Office of Administrative Hearings, and I have been assigned to preside over this matter. We have a quorum here today. May I have the appearance of counsel, first starting with the Deputy Attorney General.
Good afternoon, Christine Reed, Deputy Attorney General for the complainant.
Thank you. And for respondents.
Good afternoon, members of the panel, and Your Honor, I'm David Balfour, and this is my client, Kenneth Weissman.
Thank you. The board has issued an order of non-adoption of a proposed decision by Administrative Law Judge Levy in this matter and has decided to determine the matter itself. The board has instructed that oral argument shall be directed only to the question of whether the proposed penalty should be modified. So the following time limits will apply. The respondent will have 15 minutes to make an opening argument. The Deputy Attorney General will then have 15 minutes for a response. The respondent will have 5 minutes for a closing argument, and the Deputy Attorney General will also have 5 minutes for closing argument. These time limits will be strictly enforced, and I'll try to give you a 2-minute warning. The arguments shall be based only on the existing evidence and shall not exceed the scope of the record of duly admitted evidence. No new evidence may be heard. The panel members may ask questions of the parties to clarify the arguments, but may not ask questions that would elicit new evidence. The administrative law judge and any panel member may also ask a party to support the party's oral argument on a matter with a specific citation to the record. At the end of the oral arguments by counsel, I will offer respondent position an opportunity to address the panel regarding the penalty, and sir, if you care to do so, I will place you under oath and have an opportunity to address the panel. After oral argument, the board will go into a closed session to deliberate. The parties will not receive a decision today, but it will be received in the mail in the future. Please remember that all the arguments must be based on the existing record and no new evidence will be heard, and the board has had the benefit of reading your briefs. All right, so at this time, let's begin with respondent. You have 15 minutes, and you may begin.
Thank you, Your Honor, and thank you, members of the panel. We believe that the record overwhelmingly supports the granting of the license to Mr. Weissman, subject to appropriate probationary terms and conditions. We believe Judge Levy added a reasonable and appropriate set of recommendations for probation and terms in his decision, as I outlined in my brief. Maybe this is somewhat unorthodox, but I think the panel, most likely in this case, wants to hear directly from my client. And so it's my intention to turn it at this point to my client so you can hear from him, as well as reserving time for questions.
In that case, sir, Dr. Weissman, please raise your right hand. Do you solemnly swear or affirm under penalty of perjury that the testimony you're about to give in this proceeding will be the truth and the whole truth?
I do.
Thank you. You may address the panel.
I'm grateful for the opportunity to come here and address the panel with my somewhat personal take on granting the license and the decision. In February, it will be 2 years since I've submitted my application to the medical board for licensing, and the good news is I've been sober another 2 years. The bad news is I've been out of practice another 2 years, and I know that both of those play into the decision making. 2 years is a long time, and I think that the perseverance alone might hopefully show you something. here to tell you that I'm ready to reclaim my profession and to move forward with my life in all aspects. I will never take for granted the solemn, honor and privilege of practicing medicine. If I have been guilty of that in the past or negligent in any way, which I have been, and I've accepted responsibility for that. But for a number of reasons, as outlined in David's brief, we do feel that the overwhelming evidence supports granting me some sort of a license to practice medicine. I traveled here from Florida. I was visiting my dad, and I'm the first, physician in my family, and obviously very proud of me over the years. And then as I struggled, it was very difficult. But he gave me some advice, and he said I should approach you, and I should just say, what can I do to alleviate your concerns? Because obviously you have some, I wouldn't be here. But I feel that I have done everything that I can in my power to stay sober and to work a good program of recovery, as well as to stay current in medical knowledge. So, and I think that that's evidenced by the record. Briefly, I want to talk about my recovery. My sobriety date, September 12, 2012. I have a sponsor, Kent Howard, also happened to be my dentist. And Kent told me that if I stay sober and continue to do the right thing, that I will be able to practice medicine again. I sponsor 3 guys, go to a lot of AA meetings, probably 3 to 5 a week. I've been in Dwayne Rogers' group, monitored healthcare professionals in recovery now for over 4 years. And I've also been monitored by Mike Sucher of Greenberg and Sucher with random urine testing for the last 4.5 years. So, we feel that all of the witnesses that we presented have testified that I'm a well-trained, skilled physician who is safe to practice with continued monitoring and treatment. They've either testified that at the hearing.
Can you slow down a little bit when you're reading?
They have either testified that at the hearing that Judge Levy presided over, or they have written letters supporting my medical skills and knowledge, my commitment to recovery, my gifts, my desire to give back and to help others. Dr. Sucher, his credentials, medical director of the California Physicians Health Program, Arizona Physicians Health Program, past president of Arizona Society of Addiction Medicine. His letter, Exhibit F, says that, quote, Dr. Weissman has been in full compliance with program requirements, including continuing psychiatric care and compliance. All urine drug screens have been valid and negative. He demonstrates high-quality sobriety, and his prognosis for ongoing successful recovery is excellent. There are no safety issues regarding his practice of medicine. He goes on to talk a little bit about the Colorado board, in that I have been granted a probationary license in Colorado, which I know is one of the grounds for your denying me a license. However, the other side of that a lot of people cite is that it is a vote of confidence that I have been granted a probationary license by another state's medical board. So he also testified at our June hearing that when asked about fitness for duty, he says he's evaluated thousands of physicians for fitness of duty, and that he certainly feels that for the last 2.5 to 3 years, he believes that I have been fit for duty. He recommended an additional 2 years of monitoring. Dwayne Rogers, who runs the group, the Pacific Assistance Groups that I mentioned formerly, he also believes that I'm ready to go back to work based on his 34 years of doing what he does. And he says that this is based on his commitment to medicine, his commitment in terms of staying current, attending continuing medication seminars, and discussions in group about how he would like to practice and what he would like to do. Other expert witnesses, Dr. Marion Chiatti of the Colorado Physicians Health Program also testified, or excuse me, Exhibit 5 stated that she felt that from their perspective, I was safe to practice. My psychiatrist, Dr. Howard Richmond, also testified the same thing. I think one of my strongest witnesses, she didn't get to come to the hearing, but she wrote a wonderful letter, and if you'll indulge me, I'd just like to be part of it. Karen Van Hosen, Dr. Van Hosen, has been a licensed California physician since 1991.
If you'd also be mindful of your pacing so we can appreciate what you're saying, and also the court reporter can.
Yes, I apologize. She has been on the UC San Diego faculty since 1993 in emergency medicine, expert in wilderness medicine, hyperbarics. I just want to read a brief portion of her letter. I am a clinical professor of emergency medicine at UCSD and work in the emergency department and urgent care, treating patients as well as educating medical students and residents at UCSD. Additionally, I am a member of the UCSD Physician Well-Being Committee, and I am very familiar with drug and alcohol addiction and recovery programs for physicians. We work closely with the UCSD Physician Assessment and Clinical Education, that is PACE, program that helps physicians following recovery integrate safely back into clinical practice. Ken continues to have an extremely successful recovery program. He has been sober since September 2012, was granted a probationary license in the state of Colorado in 2014. He has maintained his emergency medicine board certification and passed his recertification examination in 2012. He's actively pursued continuing medical education despite being out of practice, which is a testament to his strong commitment. I've had many conversations with Ken regarding his desire to obtain his California license and continue working in emergency medicine and urgent care. He additionally has a strong interest in addiction medicine, wilderness, disaster relief, and volunteering. His intentions to re-engage are genuine and heartfelt. I know he has excellent skills and training to share with other physicians and patients. I can see Ken playing an important role in addiction medicine, using his experience to benefit others. I just briefly want to turn my attention to the case presented by the board's attorneys as far as the arguments, statement of issues, and so on against me. I know they feel that the administrative law judge's decision was too lenient, and the proposed decision of a 3-year probationary license, along with successful completion of the PACE program, continued monitoring and psychotherapy. My attorney has already told you, in his brief anyway, that, quote, the preponderance of evidence established that respondent may safely return to the practice of medicine under specific terms and conditions, including the requirement he successfully complete an education and training course and remain under a monitoring program to ensure his continued sobriety. I know in their brief there's a long history of substance abuse that is well documented. We're going to talk about DUIs, we're going to talk about rehabs, and it's all true, and it's all based on my testimony, my honest, candid testimony. There are no expert witnesses against me saying that I'm unsafe to practice. The entire case against me is built on my own self-reported admission of, I mean, there's a trail of wreckage. I'm not proud of a lot of the things that I did, and as healthcare professionals, we come in to recovery with a lot of guilt and shame, and I've had to forgive myself and move forward the best that I can. They say that the proposed penalty must be modified, it's too lenient. They say that, they quote, that absent mitigating or other appropriate circumstances, such as rehabilitation or early acceptance of responsibility, the board rightfully expects proposed decisions to follow the disciplinary guidelines and uniform standards. I'm saying that early acceptance of responsibility and rehabilitation is exactly what I've been doing for the last 4 years. And the next thing that they go on to say is that outright denial is necessary and appropriate to adequately protect the public and in respondents' rehabilitation. The only disciplinary penalty that will adequately protect the public health, safety, and welfare is the outright denial of respondents' request for licensure. And they talk about the statement of issues, including that I demonstrated a lack of knowledge while taking the clinical assessment at the direction of the Colorado Medical Board in November 2012. In fact, I was found during the CPEP assessment to demonstrate, quote, a good foundation upon which to return to practice. At times outdated. You know, urgent care and emergency medicine is a lot of information, and I expected to know about pediatrics and orthopedics, and there's a lot of stuff. I don't think it means incompetence. I think it means rusty. I think it means I'm human, and there's a lot of things new medications and so on that you can look up. You know, that's what people do. Okay. You know, I think outright denial at this point, in the face of all of this evidence, would be unfair. I think it would be a disservice to me and to the patients that I would help. I don't think it sends a great message to physicians that are asking for help. I think outright denial would deny me the opportunity to be of service. And if you know much about recovery, being of service is a big part of it. You know, and disaster medicine, addiction medicine. I cannot be board certified in addiction medicine if I don't have a valid license to practice. You know, this argument of 30 years of drinking versus only 4.5 years of recovery, I mean, I don't feel that it's a good argument. And things didn't really get bad for me until the last 5 years. Obviously, I went to medical school, I did a residency, I worked at the Mass General Hospital. There was a lot of years that this is a progressive disease if you know much about it. You know, there was a lot of years that I was a very, very functional, high functioning physician. And, you know, in summary, you know, perhaps look at it as a risk-benefit thing, this theoretical risk that I may harm some patient. Look at all the benefit that I could do by you working with me to grant some sort of license. I'm willing to do what it takes. I'm here to tell you that whatever your fears are, whatever your concerns are, I'm here to work with you, and let me know what I can do to alleviate your fears, and in return, I will do my best to stay sober, to keep current, and to be a good physician as I've always been. If you read these letters, if you have a friend, a colleague, a family member who struggled with addiction, read these letters. I think you would be rooting for someone like me to move forward with their life and be successful. Thank you.
Thank you. Ms. Reed?
Thank you, Judge. The board asked for argument on whether the proposed penalty should be modified. It's the complainant's position that yes, the penalty proposed should be modified because the severity of the respondent's substance abuse issues and the questions raised about his competency warrant the outright denial of his application for licensure. The medical board adopted the manual for model disciplinary orders and disciplinary guidelines in order to implement the mandates of Business and Professions Code 2229.
Can you slow down a little bit?
Yes, sorry.
Business and Professions Code.
Section 2229, which states that the board's highest priority is the protection of the public. The rationale behind the guidelines is that by tailoring specific disciplinary action to specific causes for discipline, the guidelines would promote uniformity, certainty, fairness, and deterrence throughout the state, which would also further public protection. In addition to the manual, the medical board has also instituted uniform standards for substance abusing licensees. Similar to the guidelines, the uniform standards sets up appropriate conditions for physicians who are determined to be substance abusing licensees. Again, the rationale behind the creation for the uniform standards is the same as the disciplinary guidelines. The board furthermore expects that the guidelines be followed after mitigating or other appropriate circumstances, and that the uniform standards be used without deviation pursuant to California Code of Regulations, Title 16, Section 1361.5, Subdivision D. Here, following a hearing on June 28th of last year, the administrative law judge found that cause existed for the 3 causes for denial that were pled in the complainant's statement of issues. Specifically, the ALJ found that the respondent's license was disciplined by the Colorado Medical Board, that he had excessively used drugs or alcohol, and that he had demonstrated incompetence or a lack of knowledge in an evaluation ordered by the Colorado Medical Board in November 2014. The appropriate discipline for each cause for denial is outlined in the guidelines and the uniform standards. For discipline in another state, the minimum penalty is the minimum penalty of the equivalent California cause for discipline or denial. In the stipulation with the Colorado Medical Board, signed by the respondent admitted to habitually or excessively using or abusing alcohol. The complainant's second cause for denial in the statement of issues was for the excessive use of alcohol, a violation of Business and Professions Code Section 2239. The minimum penalty for excessively using alcohol is revocation stayed with 5 years of probation while the maximum penalty is outright revocation or denial of licensure. The complainant's third cause for denial in the statement of issues was for incompetence, which is a violation of Business and Professions Code Section 2234, subdivision D. And again, the minimum penalty for incompetency is revocation state with 5 years of probation, while the maximum penalty is revocation or denial of licensure. That being said, the respondent's history warrants the outright denial of the physician and surgeon certificate. It is undisputed that the respondent suffered from substance abuse disorder, mostly after alcohol, for a very long period of time. The respondent had started drinking when he was in college, which he graduated from in 1981. The respondent testified at the administrative hearing that his drinking grew progressively worse, and that he went through medical school, residency, and continued working, while he went through medical school, residency, and continued working in emergency medicine. The respondent testified that he believed his excessive drinking was fueled by his genes and also the stress of working in emergency medicine. Things came to a head in 2008 when the respondent stopped practicing in Massachusetts and took a leave of absence. 2008 was also the first time the respondent entered an inpatient facility for substance abuse. Following this program, the respondent moved to Aspen, Colorado, where his drinking increased. Dr. Weissman testified that in addition to drinking excessively, he started using cocaine and other prescription medications. He admitted to prescribing pain medications in other people's names for the purpose of taking the medication for himself. And he said that because of his addiction issues, he lost his job as a ski instructor. He got in trouble with the law with DUI conviction and DUI arrests. And he took a plea deal to a misdemeanor medicine charge. And he also grew physically dependent on alcohol. The next turning point occurred 4 years after the respondent moved to Colorado when his family staged an intervention in 2012. He entered Crossroads Rehabilitation Center and reported his addiction issues to the Colorado Medical Board after being told that it would be reported to the board by others unless he did it himself. The Colorado Medical Board issued an interim cessation of practice agreement in October 2012 and eventually put the respondent's license, which he already had at Colorado, on probation for 5 years in May of 2014. As a condition of his probation in Colorado, the respondent had to submit to an evaluation to determine whether he had sufficient knowledge and skill to return to the practice of medicine, since he had stopped practicing in 2008. That evaluation was to take place within 120 days of the effective date of the decision and order that put him on probation. Dr. Weissman was unable to complete the evaluation within that time period because he was hospitalized in the summer of 2014. The respondent spent approximately 2 weeks at McLean Hospital in Massachusetts and spent time thereafter recovering on the East Coast. While in McLean, Dr. Weissman was diagnosed with bipolar disorder and treated with medication and eventually electroconvulsive therapy, which continued for a brief period of time when he came back to Southern California. The results of the respondent's November 2014 evaluation at the direction of the Colorado Medical Board showed that his general knowledge was good, but that his knowledge of certain subjects was outdated or incomplete. The evaluators found that Dr. Weissman had deficiencies in multiple subject areas and in the way that his knowledge was limited or outdated, which makes sense given his lengthy absence from practicing medicine. They recommended that he take a physician-patient communication course, independently study at the evaluator's direction, continue to take CME courses, and complete a clinical experience with an educational preceptor. Dr. Weissman has done all of these things with the exception of the clinical experience. As of the date of the hearing in June of last year, his license with the Colorado Medical Board was inactive because he was unable to complete all of the conditions of probation because he was currently living in California. And he has not practiced medicine since 2008, over 8 years ago. In the board's consideration to grant the respondent a license, the board should review a number of things in the respondent's history prior to making their final decision. Certainly, his substance abuse disorder is the most significant reason why we're here today. And while the respondent has provided evidence of rehabilitation and sobriety since September 2012, the complainant would remind the board that while the respondent has been sober for over 4 years, he has been drinking for over 35 before that. The evidence from the hearing established that his addiction to alcohol not only affected his personal relationships, but also significantly affected his professional life. Starting in 2008, the respondent went to 4 rehabilitation programs to try to treat his addiction. According to his testimony at the hearing, the respondent has had multiple contacts with the criminal justice system because of his drinking. Dr. Weissman admitted to inappropriately prescribing opiates in other people's names and using them for himself when he was in the throes of his addiction. His over 4 years of sobriety should be carefully weighed against the severity of his addiction before that sobriety, pursuant to California Code of Regulations, Title 16, Section 1309, which lists the rehabilitation criteria for the denial of licensure. Subdivision A of that section states that the nature or severity of the acts which are the grounds for denial shall be considered. It was well established at the hearing that the respondent's substance abuse issues were severe and longstanding. The third cause for discipline is another issue that the board should consider in addition to the respondent's addiction to alcohol when determining whether or not the respondent should be granted a license. Dr. Weissman did not dispute the findings and recommendations from his 2014 evaluation. Dr. Weissman has been unable to complete the evaluator their recommended training and experience because he relocated to California and cannot practice. The board should review the respondent's ability to practice most and vis-a-vis his competence in the subject matter while making its ultimate decision, in addition to his substance abuse issues. It is commendable that Dr. Weissman sought help for his alcoholism and has taken measures to maintain his sobriety. The respondent just told the panel that it would be unfair if he wasn't granted a license. That is not the board's ultimate focus. The medical board's motivations behind carefully evaluating and denying applications for licensure go back to its mandate to protect the public. The board is duty-bound to protect the public from physicians that have the potential to harm patients, and the board exercised that duty when it denied the respondent's application for licensure. The complainant would respectfully request that you do the same today. Thank you.
Thank you. This is an opportunity for response by respondent, 5 minutes.
Let me just make one comment in terms of the protection of the public. I think what we saw from Judge Levy's decision was that he did carefully consider the evidence and weighed the evidence, and he tailored his decision to provide probationary terms to respond carefully to the issues that Mr. Weissman has told you about. As to substance use, Judge Levy ordered that Mr. Weissman have 3 years of probation, continuing on with the monitoring and testing that he has undergone over the past more than 4 years. So that is consistent with the uniform standards. Judge Levy also addressed any concerns regarding competency, because in addition to the CPAP or the Colorado evaluation, Judge Levy ordered that Mr. Weissman go to PACE and successfully complete the PACE assessment before returning to practice. I'll let Mr. Weissman add one more comment, and then we'll open it to questions.
Yeah, I mean, I just want to say, quote from the Big Book of Alcoholics Anonymous, page 84, it says, "No matter how far down the scale we have gone, we will see how our experience can help others." And I want to be of service, and I feel that I deserve this opportunity. And like I said, I'm here to work with you, and I'd love to answer any questions or concerns that you have. Thank you.
Thank you. Ms. Ree, you have an opportunity to respond. Any response?
Mr. Balfour talked about how the 3 years of probation with continuing monitoring provided by the uniform standards. The complainant's position would be that they actually, in fact, do not conform with uniform standards, which actually require at least a minimum of 5 years probation. And again, the complainant would argue that those standards should not be deviated from in this case. If the panel's inclined to grant Dr. Weissman a probationary license, we would ask that you consider the severity of his substance abuse disorder, consider his complicated history. During the hearing, we had asked for 7 years of probation. We believe that would be sufficient time, or that would sufficiently and adequately protect the public. We'd be asking for that today if the board is inclined to grant a license, and at the very, very minimum, if they're willing to grant Dr. Weissman a license, we would be asking for at least 5 years with the full PACE program, because Dr. Weissman, his competency and his skills as a doctor haven't really been used since 2008, and he was assessed in 2014, which is now over 2 years ago. So we'd be asking for full PACE and all of the conditions that Judge Levy imposed in the proposed decision. Thank you.
Thank you. This is an opportunity for questions by the panel. We'll start with Ms. Pines. Do you have any questions?
I do not have any questions.
Dr. Lawson?
I'm not a doctor, but I don't have any questions.
Oh, sorry. Dr. Bella?
No question.
Dr. Levine?
No questions.
And Dr. Gannabet?
Yeah, I do. Dr. Weissman, the primary mission of medical board is protect the public, okay, period. So we went through your entire life story about what happened with drugs and alcohol. Why do we need to take a risk of potential consumer harm in California by granting you a license? I understand why, because if you practiced in Colorado for 5 years without any problem and applied, I think it's a different compared to, you haven't been practicing for about 8 years, maybe 9. And it's not riding a bike. It's very difficult to practice. One good thing is at least you're not asking for to be a surgeon, which skills go away if you don't practice. So explain to us why we should take that risk of a potential harm to California consumers.
You know, I think, I don't think I've set any records for bad behavior. I mean, I know physicians that I am in groups with, you know, who are drunk in the operating room or injecting, you know, opiates in the operating room. And there's a lot of stories, but these people are dedicated to their recovery, and they're better doctors now than they were before. I feel like I would be a better doctor now than I was before. You've read the letters in terms of my commitment and so on, and I talked a little bit about risk and benefit, you know, so you cannot protect everybody against every doctor any more than you keep your kids in the house so they don't go outside and get run over by a car or something. There's going to be a risk that you have to decide is acceptable or not, compared to all the benefits that I could do. Talk about the opioid epidemic, you know, compared to the benefit that I could do as, say, a specialist in addiction medicine or anything else. You have to decide that. You have to decide if I'm an incorrigible bad doctor, or like all these letters and testimonies say that I'm essentially a good doctor who struggled with this disease of addiction, came through the other side as a better human being and a better physician.
Let me ask you the next question. So usually, you know as well as many of us here that it's very difficult to get a job, not just a license. How are you even thinking about how you're going to practice if you get a probationary license for a very, very, very long time? So I just want to hear from you how you, because many insurance companies won't take you. Medicare and Medicaid don't take you. So, I mean, these are all the issues you have to consider when you ask for a license in any state. So I'm just wondering what you would talk about on this.
I'm just putting one foot in front of the other. You know, I feel that there's a higher purpose to me practicing again. I don't know where it's going to lead me. I do think it can lead me to help other folks with addiction. I think there's a lot of opportunities in the recovery community to practice. Also, Dr. Van Hosen has agreed to precept me in the urgent care center that she works at. I have a lot of contacts. You know, I feel confident that I will be able to get back to work. But that is the kind of thing that I turn over to my higher power, and I just do the next right thing.
Dr. Cross, any questions?
Dr. Weissman, was there or is there intent to practice in Colorado under the conditions of the probationary license there?
You know, when I moved here in 2012, I knew I had to leave Aspen. It was not a healthy place for me to be, and that coincided with my sobriety date. The recovery community in San Diego, where I live, is so wonderful and strong. I have so many friends in the fellowship and my sponsor, and I just feel that this is my new home, and going back to Colorado for me to comply with this, their order is just not an option. It's just been such a healthy place for me to be in recovery here. And I'm happy here, and I have a home and a dog, and I've just been very healthy lifestyle here for me has been wonderful.
Thank you.
Any additional questions from him? Hearing none, at this point, the record will be closed. We will conclude the arguments. The case will be submitted. We'll go off the record. The panel will deliberate in closed session. Please give it for our record.
Thank you.
Thank you.